I'm Bill Oughton of Oughton Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster.
Hello, it's Chantal by myself again. Welcome back to the Art of Adjusting podcast, the show where we're going to talk claims, common sense, my opinion. I'm going to get up on a soapbox. We never know what's really going to go on. I am flying again solo, and Bill is out again this week. I think Mrs. Bill is having him finish up his honey-do list. Either way, you are stuck with me. So, lucky you, right? So I decided that today I would handle a pretty difficult topic, and I probably shouldn't because, Bill will always keep me reined in. But I thought, what are we going to talk about today? And I've come across this a few times in my expert witness cases. It's one of those damned if you do, damned if you don't kind of situations that adjusters often find themselves in. It is a tough and difficult situation. And this is the situation when you have written in the estimate, you've cut the check, you expect the insured to begin repairs, they have a contractor, and nothing is happening. Months go by and damages continue to accrue because the insured is not doing the repairs. It is kind of a fine line, like I said, because you as the adjuster and as the insurance company, you can't tell the insured to begin repairs. And so, what do you do in this particular instance? But on the flip side, we have to understand the reason why the insured is not beginning repairs. It could be several different reasons. So I thought that I would touch on some of those things so that we could get them addressed and see if we can't get our claims moving and resolved. Of course, we're going to be talking about like the kind of claim where we don't have maybe a preferred vendor working, because I think preferred vendors, that's something different where we have the preferred vendor coming in and they do the work as soon as they get the estimate written or whatever. So I think that's something completely different. And y'all are just going to have to deal with me having like a little bit of long pauses, because usually I let Bill fill in these long pauses while I'm taking a sip of tea because I'm thirsty. But yeah, today you're just going to have to deal with some long pauses as I, drink my tea. And it might even give me a chance to like rethink what I'm gonna say. Who knows? We never know what's going on in my mind, do we? It's always a kind of a surprise. So, how do we as adjusters, walk this line of we can't tell you what to do, but your policy does tell you as the insured that you have to protect the property from further damage. And how do we get the insured unstuck? Because they may be waiting on this mythical final estimate idea, or maybe their contractor, their estimate is much, much higher than our estimate. And it's not unheard of. I think we can all agree that even if we go out and write the scope of damages with the contractor of choice, our estimate will be different. And it's not beyond the realm of disbelief that the contractor has already given the insured an estimate or a price, a quote, and they didn't share that with us. They, either the contractor or the insured, didn't share that with us. So when the insured gets this estimate from us and it's vastly different, even though we walked the premises together and did an agreed scope, it creates this fear, I guess, is the best way to look at it. So let's, get into all of these things. I think the first thing is talking about this fear is, what is it? Why do policyholders delay repair? We've given them in the estimate, right? And let's just say it's, I don't know, a pipe burst in the wall or something like that. Uh, you know, Maybe it's an HVAC system that's in the attic and it's been leaking. So now we've got it coming down from the ceiling and maybe in the walls or something like that. And so basically we've got some, I don't know, let's just say $50,000 worth of damage. Okay. We'll just go with that. Yeah. And why do the insureds have this fear? Okay, well, I think first we can address the elephant in the room that everybody has told the insured that the carrier is going to screw them over. Period. Everybody has told them this. Everybody knows it. We know it. We know that the carrier is not going to screw them over because that's not what we're about. But we know that that's what the thinking is. Why? Well, it's because we see these car advertisements or these home advertisements that say, oh, you've got a ghost in your house. Well, they didn't do it back in like they did in our days, and just, bundle and save with us and we'll write you a check. That's what people think. They don't recognize, as we've talked about many, many times before, that there are exclusions or conditions that they have to do, or maybe we pay actual cash value first, or maybe there's a sublimit, or maybe mold isn't covered. I don't know. Who knows what their policy is, but each and every policy is different, even if you're living right next to one another, right? In the same, with the same insurance company. Okay. So we've got that, thinking that they're going to screw us over. The insured is thinking the carrier is going to screw us over. So I don't want to begin repairs until I have the carrier sign off on all of the damages. Because the minute I begin repairs is when any additional damages that I find will not be covered because they weren't initially seen. And I've seen this before, where the insured won't want to do something because they are basically frozen because they're afraid that if they start repairs and more damage is found, that damage won't be found or won't be covered. And here's the thing that we need to address. We understand that they are scared, even if they themselves wouldn't even categorize that as being scared. No one sits around going like, oh my gosh, I'm so scared of the insurance company. Am I right? Nobody sits there and thinks that. And most policyholders are not being difficult. They are scared. They are worried that you're not going to give them the full amount of money to repair these damages because, again, based on the popular culture of what everybody has told them, they're scared to make a mistake. They're scared to be left holding the bag. They're scared that their premiums will go up if they act without permission or if they repair damage. Heck, they're scared that they're going to lose coverage because they've been hearing about what's going on in California and everything, like how people are being dropped because they their houses burned down and they've submitted a claim. right? This is where this fear comes from, even if it is not actualized as fear. Maybe it's actualized as just generalized anxiety. And who knew that insurance adjusters also have to be psychologists in addition to everything else that we have to be, right? Physicists, doctors, lawyers. I mean, we've got to know so many things. We've also got to know a little bit of psychology. So, knowing where this fear comes from can help us address this. It could be like a contractor or a public adjuster also who's saying, "Hey, don't touch anything until you get a final estimate." Well, let's just touch real briefly on that. I don't think there is anything as a final estimate. I don't think there's anything like that because we won't know what the final damages are until obviously the repairs are done. I mean, that's going to be the final estimate, and we can't you can't just sit there and let it go because we're never going to get there kind of deal. It's kind of like a circle, right? So the problem is, of course, this is not how our policies work. And insurance isn't like a permission based sort of thing. It's a responsibility based. Like this is your property. You got this policy to protect it. That's your responsibility. We can help you with it, and a lot of times before carriers have started going over to the preferred vendors a lot for property damage. For example, it has always been a big deal in auto, but it's now coming over into property more and more. But you see these preferred vendors, not necessarily for remediation, like with our water damage, pipe burst kind of deal, where we would get our water remediation people to like dry out the carpets or put dehumidifiers out there, or at least do a flood cut on the drywall or whatever, and then wait for the insured to find another contractor to finish out the repairs. This isn't that, but in some instances, and I guess still some today, I don't know. Y'all drop me a line and let me know if this is still what's going on. You have these people who they're frozen because they don't know what contractors to use. And also, again, going back to our job as a carrier and as adjusters, we can't recommend anybody. Because what happens when we recommend someone? Well, we're kind of saying, like, yeah, their work is good, right? And we can't really do that, which is a whole thing about preferred vendors. Will it not even go there right now? So I'm going to drink my tea and go somewhere else with this. So let's address this fear. Let's talk about what the policy actually says. I think we are all aware of the policy conditions, which says, hey, you got to cooperate with us, in our investigation. You have to let us look at everything as often as we want. You have to report the loss to the police if, you've had a break-in or something like that. Okay. There's also, which we know, the duty to cooperate and the duty to protect the property from further damage. Now, the issue is that this is not a suggestion, it's a condition for coverage. It says, look, if you don't protect your property from further damage, ensuing loss, you're not going to be covered. And again, think about what this policy is saying and think about how people could mistranslate this. We're saying, and the policy says, if you don't protect the property and we find additional damage, we're not going to cover it. Well, what does the insured immediately think? Oh my gosh, I have additional damage. They're not going to cover it. This is why they are sitting on things, right? So we need to address, again, the elephant in the room and translate insurance ease into plain English. And it also is horrible that adjusters are having to be translators in addition to being psychologists and auto mechanics and construction workers and doctors and lawyers and all of the other things that we have to be. But here we go. We have to be linguists and translate insurance ease over into English. And so it means that, you know what, if you've got a burst pipe and water is streaming down your wall, you've got to turn off the water to the entire house. Sorry. I mean, unless you can turn off the water to that one particular pipe, and maybe you can. I have no idea. I don't know how your house is set up. Maybe you can. Then that's what you need to do. If you have a leaky roof, of course, you would put a tarp over it. If there's water intrusion, you gotta dry it out. If there's broken glass because someone hurled a brick through it or whatever, you need to put some plywood over it and protect your house. You board it up, right? I mean, these are common sense things that the insured would need to do to protect their property. If the insured waits, for example, let's say with the window, well, that just allows all sorts of kids and vagrants or whomever to come in, start spray painting everything and blah, blah, blah. And well, that part is not going to be covered because that's an ensuing loss, right? I mean, that makes sense. And I think if we start talking to the insured and explaining these things to them, then they understand that. Because here's the catch again, they don't know, right? So, how do we explain this, their duties and the conditions and everything without it sounding like, they're on their own or that we're, oh, I don't know, we're punishing them or something to that effect. Well, I think the first part that we need to do is actually talk to them. Set down a time and say, you know what, this is probably going to be, I don't know, a good 15-minute conversation, maybe 30 minutes. I don't know. Overestimate, if anything, and say, I need your undivided attention. Go somewhere where you can listen, and I'm going to explain this to you. I usually do this with when I get the estimate and I've approved it for payment. I will sit there and go over it. Okay, so the total damages are $1,000. You have an RCV policy, so the damages are 1,000. You have a $5 deductible, so it's $9,995. You would pay the $5 deductible. We would pay ACV, actual cash value, first. Boom, this is what this is. When you finish repairs, you would get, let's just say the recoverable depreciation was, I don't know, $5,000. That means that I'm paying you, I'm writing you a check. I'm going to cut you a check right now to you and your lien holder, because it's a house, in the amount of, what was that, $4,995, right? If I can do my math in my head. And then when you complete your repairs, I'll either go back out there or I'll send someone back out there, or I want you to send me the receipts showing me that you've completed the repairs, whatever, however your company does it. And then you can earn up to $5,000. It's not an automatic thing. Not an automatic thing. Now, you may be wondering what to do. Here's what the issue is. You now have the estimate. You will have the check. We can't tell them to start repairs because it's not our house, right? And if something goes wrong during repairs, we don't necessarily want that liability. But what we can say is, I can't tell you what to do with your property, but I can tell you what your policy requires. Okay. I can't tell you what to do with your property, but I can tell you what your policy requires. And then say, I'm giving you your estimate. I'm giving you your money. You can have your contractor begin repairs if additional damages are found. Have her stop the work and contact me. Boom. That's what we're doing. We're telling them that we recognize that there are going to be supplements. And in fact, I have even gone so far, depending on the insured, the savviness of the insured, to tell them if you find additional damages, and more often than not, we are going to find some. This is called a supplement. We are all used to this in the insurance business. And if your contractor is worth his or her salt, they know about it as well. So when your contractor says, oh, hey, this is actually not on the estimate that the insurance company gave me, there's going to be a difference in prices. We're not ripping you off. We're not lowballing you. We just didn't know about it. It's called a supplement. We would send someone back out there and take a look. If it's covered, if it's a covered part of this loss, then we add it to the original estimate and we cut you another check. That's the supplemental process. If it is not part of this loss, let's say that it's pre-existing. I don't know, maybe it's pre-existing. We can open up another claim. You would owe another deductible, but it's not going to be covered under like this loss. So this could be one of the reasons why my estimate differs from your contractor's estimate. He has written an estimate for all of the damages, but let's just say, I don't know, we've got a leaky HVAC system in our attic or pipe burst, and it happens on the left side of the room. And the contractor has written damage for the right side of the room. Well, obviously the water hasn't gone over there. And we can tell that this water damage is much older because of the rings or I don't know, whatever, mold maybe, I have no idea. But we can tell that it's different. We would have said, okay, so the right side of the room is a different claim. Yeah, I mean, if you put everybody's estimates together, then yes, our estimates would equal his estimates, but your contractor, or your contractor, is writing out one estimate for the entire room. We're only focusing on this date of loss, so we're only focusing on the left side of the room. This would be another way to explain this fear. It's not that we're lowballing you. It's not that we're ignoring some damages. It's that this is a different claim. Yes, your policy would cover that. It would be a different date of loss, a different deductible. At least with some insurance companies. Now, some insurance companies will just throw the whole thing in. That's not the point. But now, so that is how you would explain it, depending on, I guess, the savviness of your insured, because I think it does really depend. If it's like grandma, I do tend to spend more time explaining it. If it's someone who is savvy and can follow along a little bit better, I do gloss over more things. Now, again, that's not saying don't use that against me. That's not saying that I tell people different things. I don't. I'm telling them the same things, but I am breaking it down in ways that they can understand it and putting it in terms that they can understand or using examples that they can understand. Okay, so let's see where we are. You know, the next thing after you've had this long conversation with them, the insured, that is, and you know where I'm going with this. All of you who, my six listeners, our six listeners know why, where I'm going to go is, yeah, after you finish talking with them, you need to put it in writing. Absolutely need to put it in writing. And I would say not only emailing these things to the insured, which is fine. I love email. I love putting things in the email, but in some certain instances, I do believe that snail mail is better. And this would be one of those instances where we are explaining the damages and how we have arrived at the damages, and what coverages are taking place, because that happens to be some of the good faith claims handling practices, or part of the Unfair Claims Settlement Practice Act, is explaining which coverages were used when we're making payment. I would again put this in writing and say something like, hey, pursuant to your policy, you would need to take reasonable steps to protect the property from further damage, and failure to do so may result in limited coverage for additional damages or ensuing losses that occur. It's not a reservation of rights letter because nothing has happened yet. But what we are doing is we're keeping it neutral, we're keeping it factual, and you want to make sure that you're not only saying these things to the insured so that they understand it, but that you are also sending it in a letter. Likewise, you don't want to just send a letter and not talk to the insured, because saying something like, pursuant to your policy, you are required to take reasonable steps to protect the property from further damage, sounds very intimidating. And we get back to that fear, right? And we need to make it human, and we need to address their humanity and their fear. And the only way that we can do that is by talking to them, by picking up the phone and listening to their voice. And I get the fact that we are all overworked. I get it. I get the fact that there's not enough adjusters. There are not enough hours in the day. All I can say is, I don't know, make an appointment and say, I need to talk to you for about 10 to 15 minutes. I want to explain this to you so that you can understand. I'm going to send you a letter, blah, blah, blah. If you have any questions, take a look at it and then give me a call back. I guarantee you, your call volume will drop. I know it's going to take a lot of work on the front end, but I guarantee you your call volume and your emails will drop. I bet you dollars to donuts. Okay, anyway, let's talk about why our estimates don't match. We mentioned this very, very briefly. We will have the difference, even if we walk the damage with with the insurance contractor. The contractor could be putting in, like I said, this whole right side of the room that doesn't have anything to do with the actual damages that this claim is about. That could be one difference. Another difference is that the contractor, maybe they put that these are premium high grade cabinets when they are, I don't know, Lowe's specials, just something that they got from Lowe's on sale, or Home Depot on sale, or something to that effect. It's no, it's not always the contractor. Don't get me wrong. It's not always, I'm not saying that the contractor is always trying to, fill out or pad the claim or his estimate, her estimate, whatever. Um, Contractors, they write the work to complete the job, to cover overhead, and make a little profit. I mean, they have the right to do that. They have the right to make overhead and profit. And our estimating platforms like Exactimate, they're not exactly gospel. They're not always going to be right. It could be a difference in scope assumptions. Um, there is the instance where the carrier has been or have been, carriers have been taking depreciation on labor, overhead, profit, and taxes. And Bill and I get into taking depreciation on labor all the time. You can go search other things, other past podcast for that. We have a lot of fun with it. We are on stark ends of it. But if your policy says that we can do it, then and well, then there's nothing I can do about that. That's going to happen. And that will be a difference from what you get paid, what the insured gets paid versus this estimate that they are seeing from their contractor or us. And again, this is something that you have to address. You must address it. You must address the fact that they can earn up to, X amount of dollars because it's holdback depreciation, but they've got to do the repairs first. It is a reimbursement, to put it plainly. That's what it is. It is a reimbursement. They got to spend the money first. It is a carrot hanging out there to make them do the repairs. That's what it is. That is what it is. So what can we do? We have to educate. So now we're teachers. Oh my goodness gracious. We're psychologists, teachers, linguists, contractors, construction workers, auto mechanics, lawyers, doctors, everything. This is why I think that this job is like fantastic. I love this job and I always encourage everybody to get into this job. But that is just me. Blue agrees. I don't know if you can hear him barking, but he is in the background barking things. Now, one of the ways that you could educate the insured is by saying, you know what, estimates are just that. They are our best guess as to what the damages are. They are a starting point. Supplements, part of the process. We are used to this. If your contractor finds related damages, stop what you're doing. We will review. Encourage documentation. If your contractor finds more damage tied to the loss, we'll reopen the claim. A lot of people, I can't tell you how many lawsuits I see because the insurance company has closed the file. Like, we've paid you the ACV and they've closed the file. The insured thinks, again, let's think about this from the insured's point of view. When something is closed, it means it's finished. I'm going to say that again. When something is closed, it means that it's finished. And think about this from the insured's point of view. Now, do we need to have like a billion claims open because, we're waiting for recoverable depreciation? I don't know. It depends on your company's rules. A lot of companies close those claims, but what you need to tell them, the insured, is here it is. This is your ACV payment. Do not say ACV payment. Explain what ACV is, of course. Here's your actual cash payment. You will earn up to, X amount of dollars for your recoverable depreciation once repairs have been completed. My file is now closed. Let me know when you've completed payment and I will reopen it. The insureds don't know that we can reopen our file. I mean, it seems so common to us. It seems so everyday to us. But I want you to think about, I don't know, neurosurgery. We don't know the first thing about it. I know I say we're doctors, but we're not that kind of doctor. And so If they say, hey, we're going to have to, close your brain up after doing some, work or whatever, and they find out that they left some scissors in there or something, what are you thinking? Like, oh my God, besides you're going to sue. Besides, oh my gosh, I'm going to have to live with these scissors in my brain the whole time. No, no, we can reopen it and, handle it and all of this kind of stuff. So these are the things that we need to tell the insured, such as, hey, you know what? If you find more damage, take pictures. Stop what you're doing. Take pictures. You're going to need pictures. You're going to need photos, scope, invoices. I don't know, proof, but not just like the opinion that I didn't pay you enough. There's got to be something there. Okay. So, there's a tightrope, like I said, that we have to walk, right? And again, this is where it kind of gets messy. You're trying to do the right thing. Your insured is looking to you. They think that you're holding out on them. The contractor thinks you're lowballing them. Everybody that is friends with your insured is telling them that you're lowballing them. The insured sees all of these attorney ads that say, is the insurance company trying to screw you over? You blah, blah, blah. So I mean, you can't say like, hey, go repair your property or whatever, but you have to say, you know, you need to protect your property from further damage. There's a difference. I can't tell you to go repair. You can't tell them to go repair their property. It's their property, but they have to protect it from further damage. And you do need to warn them, like, hey, look, if you don't, if you don't, and ensuing loss comes, additional, well, they won't even know what ensuing loss. If additional damages come from this burst pipe or this leaky HVAC system or leaky roof or whatever we happen to have, your policy may not respond to this because the policy does not respond to additional damages if the property is not protected. So these are some very nuanced things that have to be conveyed in a verbal setting. And once we've conveyed them in a verbal setting, then we can write it down. But if you just write it and say, hey, you need to protect your property from further damage and additional damages may not be covered, they don't know what this means. And what they see, what they're reading, they don't have a context. What they are reading is that you're going to deny any future claims. So they're not going to do the work until everything gets, down on paper. And that's really never going to happen until the repairs get done. And that's kind of the, paradox here. Be calm, be confident, stay neutral, but you're translating legalese or insurance ease into everyday language. If you I can't tell you to start repairs, but I can tell you that the policy says you need to protect it from further damage. If you find additional damage, stop what you're doing, take some photographs, send them to me, contact me, let me know. I'll reopen the claim. And if it is related to this first loss, this loss right here, the loss that we're talking about, I will issue you payment. If it's related to another claim, we will start up another claim. You will have to owe another deductible, but we'll take a look at that. If it's covered, I will issue payment for that, less your deductible, but it'll be another claim. So talk about those instances. let them know that they are in control. And I think that would also help alleviate some of this fear that they have, because when you give people control, they don't they don't fear. Oh, I can't even talk. That's a lot of F's, and none of them are F bombs. So, wow, they feel more in control. So, yeah. Okay. So let's talk. Here's some of the practical stuff that you can use. The policy language is your friend. The policy language, the insurance policy itself is an insurance contract. It's a legal contract. This is the contract that the insured signed on to, even if they didn't understand it. This is a legal contract that they signed. Document, of course, every conversation. Use clear, unemotional, plain English words, and then follow that up with writing. I usually have 2 or 3 good examples, analogies to use depending on who I'm talking to. Um, such as, like I said, so if we're only dealing with the left side of the wall, and your contractor has talked about the right side of the wall, that is going to be a different claim. So we can open a claim for that. You would owe a deductible, and we can write you an estimate for that, no problem. But it's going to be a totally different claim. It wouldn't be here. So that could explain why. Yeah, blah, blah, blah. You know, talk about how the uh, it's your own house, and one of the things, and it's kind of like the nuclear option that I've had to use, and I hate using it, but it is a nuclear option that I have had to use, is if you did not have insurance, what would you do? You just you ask an open-ended question like that, and I hate doing that. It's not one of my favorite go-tos. Like I said, it's a nuclear option, and I use it when everything else is not working. And insureds don't like it either, because again, remember, they don't understand why there are exclusions in the policy. They don't understand why you're not paying the same amount that the contractor says. And we can't badmouth the contractor. We can't badmouth the public adjuster. We can't do any of those sorts of things. And by the way, I know that there are a few public adjusters who listen. We can talk to the insured even though they have public adjusters. It's not like there is a confidentiality, attorney-client privilege thing. But what I would do is get the public adjuster and the insured on the phone together and do a conference call. I also, if I'm having a lot of problems explaining things to the insured, I often will get the agent involved if a public adjuster is not involved. I like to get the agent involved because the agent is someone that presumably the insured trusts. So that is something else that can be a weapon in your arsenal. So yeah, so I think that's uh, pretty much it. I would say it's a hard situation. Uh, the rules aren't always clear. The policyholder doesn't speak insurance ease. They are afraid. They don't even know that they're afraid. And you can't ask them, what are you afraid of? Because naturally, that's going to put them on the edge. You may ask them like an open-ended question like, okay, so what's your biggest concern about repairs right now? You know, Here's, by the way, just FYI, something that you need to be listening to as an insurance adjuster is if a loss, let's say, happens in January and you haven't closed your file. Let's just say you haven't closed your file and you've paid them. you've written the estimate, you've paid the insured, and you are going about your business, blah, blah, blah. I haven't closed the file. And the insured calls you in March and says, hey, we found some additional damages, blah, blah, blah. And you're like, okay, great. Yeah, no problem. How far along are you in repairs? And the insured says, oh, we haven't started repairs yet. That is a big red flag, guys. This is where you need to stop what you're doing. This is where a reservation of rights letter or non-waiver or whatever happens to be in your state needs to happen. Because now we've got 90 days of snow, rain, sleet, whatever, wind, getting into our area. If it's a roof, maybe they didn't turn off the water. It's still leaking. I don't know. This is where you do need to do your reservation of rights letter and say, okay, this is the policy language. No kidding. Like, you need to do something. I can't tell you what to do, but you need to do it. And this is the clear notice. We've already explained it to them back in January, but now in March, we need to put them on notice that this is very serious, because what happens if they're still not doing any repairs, I don't know, in July? Oh my gosh, now we've got 7 months worth of, rain, sleet, snow, leaky HVAC systems, blah, blah, blah. We, as the insurance company, would not cover that ongoing loss, right? The insured needs to know that. More so, and I know you're sitting there going, yeah, but we told them in a letter and in a conversation. Yep, nope, they don't remember it. They do not remember it. I guarantee you they don't remember it. So this is why we have to send that reservation of rights letter. Anyway, so yeah, helping them speak insurancees. That's what part of our job is, and helping them make these informed decisions without overstepping our roles. We're not here to tell them what to do. We're here to help them move their claim towards closure. And what happens if they don't do these sorts of things? Again, it's their property. It's not like you would walk into their house and mow their lawn or whatever if it needed to be mowed. No. I mean, you just wouldn't do that. That's their job to do. Okay, so I hope this helped. I hope I gave you some language and maybe some structure on this. It's really kind of dancing on a knife's edge, so to speak. I find it difficult. I find it uncomfortable to be in this situation, because you want so desperately to help these people, and they feel that you're jerking them around, but you're not really. You're kind of bound by the fact that you can't tell them about things. So anyway, take care. I'm hoping Bill will be finished with his honey-do list and be able to, move on, and we can talk more next week. I don't have a topic, so who knows what we'll be talking about next week. So anyway, have fun, enjoy, like, subscribe, blah, 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 share with your friends, all of that kind of fun jazz. Bye.
Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auton.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster.
In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.